Now, hi everybody. Just gone 1 o'clock. We make a start. Hi there, Gary. You're all very welcome. This is our lunchtime information talk on fulfilling your obligations as a social housing provider. We're very pleased here in Ballymun Community Centre to welcome everybody. We've great representation here from across the approved housing body sector, so delighted to see everybody and some familiar names on there. So hi to everybody. Thank you to Catherine and the team in the Irish Council for Social Housing for sharing that. Most of you probably found out about this in their news bulletin, so we appreciate that. I'm Claire, I'm the manager here in the Law Centre. I'll be just keeping an eye on the questions and answers and things like that for the day. For the talk, your host is Gary here, who's our managing solicitor. It's just a bit of housekeeping before Gary starts. The talk is being recorded, as you can see. We have the questions and answers box there, so we'll use that. So if something occurs to you as Gary is going through his presentation, you can pop a question in and he'll take it there and then, or we might get to it at the end, time allowing. When the webinar ends, there will be a quick survey pops up on your screen. So we hope everybody stays with us till the end and lets us know how they found. We'd be grateful for your honest feedback. So introduce you to Gary. Gary is our managing solicitor here in the Law Centre. He's an experienced human rights lawyer with expertise in equality and in disability. He's the chair of the Law Society Human Rights and Equality Committee and a dedicated advocate for social justice. Been here in Ballymun as our managing solicitor for the last 5 years. So I'll hand you over to Gary and I will share the presentation on my screen now. Thank you.
Thanks, Claire. I think I'm in trouble with you already because I didn't put up the background for Ballymun Community Law Centre. I think that was the main instruction I was given, but anyway, we'll persevere. Just want to welcome everyone to today's lunchtime information session on fulfilling your obligations to tenants, I suppose, probably what we should have put in there, as a social housing provider. As Claire was saying there, this session is brought to you by Ballymun Community Law Centre, and I'm the managing solicitor of the Law Centre. So if I just ask Claire to go on to the next slide, please. Claire's going to do the technical work here, just in case I make a mess of it. So Ballymun Community Law Centre, well, we're a law firm, but we're a charity, so we don't charge our clients any fees. We're based in Ballymun, and we've been based here for the past 20 years, and we provide free legal information, advice and representation, together with an alternative dispute resolution service. We provide that to the people of Ballymun and also to not-for-profit organisations operating in the Ballymun area. And we really seek to address the huge unmet legal need in this socio-economically deprived area. And primarily we would act in areas such as housing, social welfare, consumer access to healthcare, and other areas, I suppose, that would really address people's basic human needs. Next slide, please. Now, so today we're looking at the provision of social housing from the landlord's perspective, and specifically we're going to look at it in relation to landlords, primarily in relation to landlords who are also approved bodies. But a lot of what I have to say is also applicable to private landlords as well. Now, I'm assuming a certain level of knowledge, and the talk is tailored accordingly. However, I will go back to some basics I'm sure that a lot of you are very, very familiar with. And just to say at the outset, we work very well with approved housing bodies who do fantastic work to ensure that people have somewhere to call home. And indeed, approved housing bodies, they're central to government's plans for better and improved social housing over the next 8 years. So today I'll highlight areas that really have concerned us over the past few years when we were dealing with approved housing bodies. But I find that once, you know, if a tenant comes into us, if there's a problem, once we engage with the approved housing bodies, we can normally find a resolution to the problem or to the issues that have been raised. So our interaction is generally positive with approved housing bodies. In relation to local authorities, I'm not going to look into the obligations in relation to local authorities acting as landlords today. Hopefully we'll get to that at a future lecture. I'm just saying that in addition to acting for tenants of approved housing bodies, for the past 16 years I've also been a director myself of an approved housing body. So hopefully I'll be able to bring in my perspective on things from both sides of the fence, so both from the approved housing bodies point of view and also from the tenants perspective. So social housing, if we go back and look at what social housing is, well, it's housing or housing assistance provided to people who've been assessed as being unable to afford housing from their own resources. And it's given in a number of different ways, as I'm sure most of you will know. By far, the largest provider of social housing are local authorities. And indeed, local authorities actually constitute the largest landlord group in the state. So the majority of social housing tenants are housed in properties owned by local authorities and in the main also managed by those local authorities. And the second grouping then are social housing tenants in properties owned and managed by approved housing bodies. Now we can look at other areas as well where we have specific social housing for specific groups such as older people or people with mental health difficulties. There's also, you know, look at long-term leases where you've people who are given 10 to 20 years duration in terms of their lease. There's also, as a lot of you know, the rental accommodation scheme RAS, which is now being almost phased out and fast replaced by the housing assistance payment. So RAS and HAP are where local authorities contract with private landlords to provide housing for tenants for a specific period of time, and the rent is paid directly to the landlord, and the landlord must register with the Residential Tenancy Board, and the tenants have the full benefit then of the Residential Tenancies Act. So next slide please, Claire. The reason we're looking at approved housing bodies is to try and flag the sort of issues, as I've said, that arise when tenants of approved housing bodies come in here to the law centre with various issues. And with approved housing bodies, as I'm sure you'll know, the tenants are taken from social housing waiting list. And so say in my experience as a director of an approved housing body, good relationships between the local authority and the approved housing body are vital when it comes to housing tenants. Although certain tensions can also emerge as well. But just speaking from my own perspective, in terms of our approved housing body, we try and work where possible as a team with the local authority. So there are currently, I've just checked the register, there's currently 452 approved housing bodies in Ireland. Now that's actually a decline. Back in 2009, there were 728, and in 2015, there were 520. But at the moment, we have 452, and they account for 43,000 tenancies. So they're an integral part of the delivery of social housing in Ireland, and there's no doubt about that at all. And the government plan is for 45% of all new social housing over the next 8 years to be delivered by approved housing bodies. So approved housing bodies are absolutely central to the provision of social housing in Ireland, and the state are going to become more dependent on approved housing bodies as we move forward. So what are they? Well, they comprise of housing associations and housing cooperatives, and they're approved to provide assistance to local authorities to deliver housing under the Housing Miscellaneous Provisions Act 1992. And local authorities are empowered to assist approved housing bodies under that act. We get on to the next slide. There, thanks. So if we look at Section 2 of the Section 6 of the 1992 Act, it empowers local authorities to give assistance to housing authorities. They are local authorities in their guise as housing authorities, to give assistance to approved housing bodies. And Section 6.2 of the 1992 Act provides that assistance may be given in a number of ways, and it goes on to say by way of loan to the housing body, by way of periodic contribution, by way of guarantee of the sums owed by the body to in respect of borrowings, by way of a grant to the local body, by way of subsidy, or the remission in whole or part of loan charges incurred by the body, and then a final provision then is in relation to a contribution in kind, whether that be in relation to materials or labour or any other service. So in order to become an approved housing body under the 1992 Act, the housing association or housing cooperative must have included in its primary objectives the relief of housing needs, or the relief of poverty, or the relief of hardship, or the welfare of members of the traveller community. And so it has to provide that, and the provision and management of housing. It must also have in its constitution a prohibition on the distribution of any surplus profit, bonus or dividend to its members, and perhaps no surprise, but it's also a requirement that its assets be applied solely towards those charitable objectives. In other words, approved housing bodies are not-for-profit charities established to satisfy housing needs, or providing and managing properties to satisfy a social housing need. So approved housing bodies are the most regulated landlords operating in the social housing area. So of all the landlords that are operating, approved housing bodies are by far the ones that have to answer to the most amount of regulations. For example, they're subject to the Charities Regulator, the Residential Tenancies Board, and as we shall see as well, the Approved Housing Body Regulatory Authority that has recently sprung into being. If we go on to the next slide. Thanks. So I'll also mention at this stage the Housing Regulation of Approved Bodies Act 2019, which has established the Approved Housing Bodies Regulatory Authority as of February of 2021. And prior to the commencement of ABRA, the Approved Housing Bodies Regulatory Authority, roughly half of the approved housing bodies signed up to a voluntary code. But since the 1st of January 2022, the ABRA has responsibility for establishing and maintaining the register of approved housing bodies, and for registering organisations as approved housing bodies. So all approved housing bodies currently under the department's register were automatically deemed to be registered with the regulator as and from the 1st of January of this year. So what does AHBRA do then? Well, the authority oversees effective governance, financial management and performance of all approved housing bodies. The regulator is also concerned, and which is obviously very applicable to this talk here, but is concerned with tenancy management as well. So say in terms of allocations and rent policies, that they be fair and transparent, that there should be procedures in place to ensure effective communication with tenants, that there should be a complaints process, and that complaints process should be clear and accessible. Proper tenant management, particularly in relation to the provision of housing services that are provided to those tenants. And finally, there should be some mechanism as well in place to monitor tenant satisfaction. So there are, of course, other technicalities that approved housing bodies have to comply with, but we're not going to dive into that today. It's would be beyond the scope of today's talk. But for further information, I would refer you to the website of the Approved Housing Bodies Regulatory Authority, also to the Irish Council for Social Housing and the National Association of Building Cooperatives for further information in relation to those. Now, if we could have the next slide. So, approved housing bodies come under the remit of the Residential Tenancies Acts, and they're subject to almost the same obligations as private landlords. So the vast majority of obligations that private landlords have also extend to approved housing bodies. So approved housing bodies, they're required to register the tenancy with the Residential Tenancies Board. That wasn't always the case, but it is now. Their tenants have, as I said, substantially the same rights as tenants of private landlords, but the exceptions to those obligations are fairly obvious. But we look at them. We look at them anyway. So an approved housing body tenant can't assign or sublet the property. The grounds for termination of the tenancy obviously don't include accommodation of its own family members or indeed of itself. So again, they're quite self-explanatory the exemptions. Security of tenure as well. Now that doesn't apply to a tenant of an approved housing body if the tenancy is transient and 18 months or less. And by security of tenure, of course, I mean the right of the tenant to stay for a specific period of time. So, that right usually accrues to a tenant once that tenant has been in occupation of the property for a period of over 6 months. Rent reviews as well, well, they're permitted as per the tenancy agreement. However, they are limited to one in any 12-month period, and notice of any such review should, of course, be given to the tenant as soon as can be. If we could have the next slide there, thank you. So I suppose we look at now at landlords' obligations and rights, and they're governed, as we said, primarily by the Residential Tenancies Acts, but also by the Tenancy agreement. So first off, if we have a look at the tenancy agreement itself, now there's no legal requirement for a written tenancy agreement. So people are often surprised by that, but there isn't actually any legal requirement for a tenancy agreement. But it would be very foolish of any landlord who didn't have a tenancy agreement in place. And certainly I haven't come across any approved housing body that has failed to have a written tenancy agreement for any of the tenants that have come to our attention. So what should the agreement itself contain? Well, at the very minimum, it should identify the parties. So who is the landlord and who is the tenant? Identify the property being let, and you would be surprised. It seems a fairly obvious thing to do, but I've seen tenancy agreements that haven't specified the property or have specified a different property. So if you are using, which most people do, precedent tenancy agreements, and you're cutting and pasting from one to another, just be very careful that you get the correct details in there, and also obviously for data protection reasons as well. You don't want to have the name, which I've seen as well, the names of other tenants put on a tenancy agreement to a third party tenant that comes into us. So just be very careful around that. So again, obvious, the term for which the tenancy lasts, the amount of rent that's to be paid, and very importantly, the dates upon which the rent has to be paid. You should also have an inventory of appliances, furniture, etc., whatever was in the property. Specify as well the rights and obligations of both parties. So yeah, you should have a section for tenants' rights and obligations, and equally a section for landlords' rights and obligations. Who pays for the utilities as well? Again, that's very important, and I would put that in there. Make sure that is in. Again, put in where the tenant, whether the tenant is or isn't allowed to have pets. So that's something that's come across our desks here quite a bit as well, where you have a tenant maybe that wants to keep its pet iguana, but another neighbour objects, or somebody finds out, or whatever, and then the landlord is trying to say, well, you can't have your iguana there. The tenant says, well, it says I can have pets. So if there's anything you want to exclude from there, exclude it. If you don't want to have pets in there, stick it in the lease. Having said that, there's no right in law for a tenant to have a pet in the property. So if your tenancy agreement is silent as to pets, well, you know, it's not exactly fatal if you're then trying to get the tenant not to have a pet in there. But I think for clarity's sake, you should put it in there. Yeah, as noted before, if the landlord wishes to avail of the 6-month probationary provision, this must be covered in the lease as well. Otherwise, if the lease is for longer than 6 months, the statutory rights will accrue. The exception, of course, as we've said before, is in relation to approved housing bodies, where the tenancy is transitional accommodation, and the lease is for up to 18 months. And in such circumstances, Part 4 rights will not accrue to the tenant. Yeah, I think we look now as well at, we take a closer look at residential tenancy board disputes as well, and the housing standards. So as I previously said, approved housing bodies are subject to the Residential Tenancies Acts 2004 to 2021. The other legislation as well I'll point to at this stage are the Equal Status Acts, so that obviously you have to be very careful as a landlord not to be discriminating against tenants or prospective tenants on any of the grounds for discrimination provided for in the Equal Status Acts. So the approved housing body must register the tenancy with the Residential Tenancies Board within 1 month of the commencement of the tenancy. So you'll need to have certain information, obviously from the tenant to complete that registration process. So you need, for example, the tenant's PPS number. The other thing I'll say as well, just in terms of dealing with tenants and gathering of tenants information, you can obviously only gather and retain information that is necessary for you to have in order to carry out the particular service that you're doing. So if you're renting to a tenant, you should only be retaining information relating to that tenant that is absolutely required. The tenant will also have a right under the Data Protection Act and the General Data Protection Regulation, as I'm sure most of you will know, to gain access to any personal data that you might be holding in relation to the tenant. So if the tenant puts in a subject access request under the Data Protection Act, that data must be given to the tenant within 30 days of that request being put in, unless of course there are exceptional circumstances, and that could be pushed out to 3 months. But generally speaking, within 30 days. And that's something that we would do a lot here when tenants come into us if there is a dispute, and we're looking at advising a tenant. One of the first things that we look at is putting in a subject access request from to the landlord, requesting data that the landlord has. And I just want to be careful around that as well. Obviously, you as soon as a subject access request goes in, you can't destroy any data, and so the data must be retained from that point on, and you have to give copies of that data to the tenant. I've had situations as well from certain bodies where they look for an awful lot of information from us before granting our request for subject for the subject access request. So again, that information should be given over to the tenant or the tenant's solicitor. And really, it's only where there's a suspicion that they aren't who they say that they are, that you should be looking for further and additional information. Certainly a request from a solicitor should be enough to suffice. But you might want to maybe look for the authority from the solicitor to that the client is acting, and he's acting on behalf, or she's acting on behalf of the client. But I would just flag that data protection issue, and just be very careful, because internal communications as well have to be, if where they're involving the tenant, have to be disclosed. And we've come across some mind-blowing interactions between people within agencies when it comes to data protection. So just be wary of that. Again, when you're registering with the Residential Tenancies Board, I take it that the approved bodies will have their registration completed online. You'll have an account. If you don't have an account, you should have an account with the RTB to keep track of everything. For people that might be joining us that aren't from approved housing bodies, just a private landlord, as well, you can register by post as well. So as we've just mentioned as well, that there's no legal requirement to have a written tenancy agreement, but obviously we strongly recommend that there's one in place. But in the event that there is no tenancy agreement in writing, invariably matters will be interpreted in favour of the tenant. That's why it's really in the landlord's interest to have that. But as I said, the vast majority of tenancies, written tenancy agreements will be in place. And the rights granted pursuant to legislation then are known as statutory rights. And you also may be familiar with the term Part 4 rights. So these are statutory rights pursuant to Part 4 of the Residential Tenancies Act 2004. As amended by the subsequent legislation, which gives tenants the security of tenure that I mentioned before. Now, tenancies created after the 24th of December 2016 now have a 6-year cycle. It was a 4-year cycle, but now we're into 6-year cycles. So that's 5 years and 6 months after the expiration of the initial 6-month period. So you'll recall that within the first 6 months of a tenancy, either party can terminate the tenancy without satisfying the statutory grounds. However, again, it's important to note, I'll go back to it again, that if the tenant is given a fixed term longer than 6 months, subject obviously to the exception in relation to approved housing bodies, which can be up to 18 months, but if the tenancy agreement, generally speaking, is for longer than 6 months, then the landlord won't be able to in position to terminate using that 6-month probationary period provision. So it should be noted as well that the Residential Tenancies Amendment Act 2021 provides that from the 11th of June 2022, all new tenancies that are created will be of unlimited duration once the tenancy has lasted more than 6 months. So in other words, where a new tenancy is created after the 11th of June 2022, the tenant will have an indefinite security of tenure. And the only way to break that, obviously, is if you as landlord want to terminate the tenancy for one or more of the reasons that are allowed under the Residential Tenancies Act. So I should also, I should probably also note as well here that that Part 4 rights don't apply to student-specific accommodation. So if we could have the next slide. So once the 6-month period has elapsed, and in the case of an approved housing body, if the tenancy is transient and no longer than 18 months, that's an exception there. But if it's not, then the tenancy can only be terminated pursuant to one of the grounds provided for in the Act. So I'm going to take a good look at termination of tenancy and termination notices, because this is the thing that comes into us all the time from tenants, and be they tenants of private landlords, approved housing or approved housing bodies. This is the number one issue that lands on our desk. So we need to look first of all at the grounds. So what grounds can a tenancy be ended where Part 4, where we have the Part 4 rights. So first of all, an obvious one would be where the tenant has breached their obligations. So, for example, if a property has been damaged beyond usual wear and tear, in a situation like that, the landlord should give a written warning notice, and that notice should detail what the breach is, and give the tenant sufficient time to remedy that breach. So you have to give the tenant a chance to remedy the breach. Now, if that breach hasn't been remedied within that time period, then the landlord can serve a 28-day termination notice. And that's regardless of how long the tenancy has been in existence. So you can serve that the tenant's been there for 10 years, but breaches its obligations, fails to remedy that breach, then the landlord can serve a 28-day notice. And as with all matters relating to termination of tenancies, the landlord must not only be substantively entitled to terminate, but very importantly, the landlord must also get the procedures right. So you might be well within your rights to terminate the tenancy, but you might get the wording of the termination notice wrong. And provided the slip rule, which we look at later, can't be invoked, this could very well invalidate the termination notice and the termination itself. So we will look at termination notices in more detail a little bit later, but I'm going to mention the two breaches of tenants' obligations which are treated differently and understandably so. And the first relates to antisocial behaviour. So of the breaches in terms of tenants' obligations, antisocial behaviour would be the number one that we would come across, and then the second one would be the non-payment of rent. So as I said, in terms of antisocial behaviour, that's the one that tenants most often consult us with. So when a tenant comes into us, having been served with a notice and it relates to antisocial behaviour, we very carefully consider the nature of the alleged breach to determine whether it actually does constitute antisocial behaviour. And it has to be antisocial behaviour within the meaning of that term in the Act. And then we look to see whether the statutory provisions then have been complied with. So there are two types of antisocial behaviour that are legislated for, and one is more serious than the other. There's two termination periods then in relation to those different antisocial behaviour grounds, and they're reflective of the seriousness of the behaviour. The first is for a 28-day period, and the second is for a 7-day period. But it is worth looking at a little bit closer at section 17(1)(c) of the 2004 Residential Tenancies Act. So that's section 17(1)(c) of the 2004 Residential Tenancies Act. Now, this defines the first category of antisocial behaviour. So I mean the less serious one, as it were, as to engage persistently in behaviour that prevents or interferes with the peaceful occupation by any other person residing in the dwelling concerned of that dwelling, by any person residing in any other dwelling contained in the property containing the dwelling concerned, or by any other person residing in the vicinity of the dwelling of the property containing the dwelling concerned. So in other words, anybody in the household anybody that's affected that is in the same building as the property that's being leased, or indeed anybody that's affected within the neighbourhood. So that's what's provided for there. So if a landlord seeks to terminate the tenancy on this basis, then a written warning, written notice warning the tenant to desist must be issued first. So you have to give the tenant an opportunity to desist in that behaviour. But if that behaviour persists, then the landlord is entitled to serve a 28-day termination notice terminating the tenancy. Now, the second type of antisocial behaviour, and the more serious type, is defined again in section 17(1)(a) and (b) of the 2004 Act. And that defines it as engaging in behaviour that constitutes the commission of an offence, being an offence the commission of which is reasonably likely to affect directly the well-being or welfare of others, or to engage in behaviour that causes or could cause fear, danger, injury, damage or loss to any person living, working or otherwise lawfully in the dwelling concerned or in its vicinity, and without prejudice to the generality of the foregoing, includes violence, intimidation, coercion, harassment or obstruction of or threats to any such person. So we can see here that that's quite serious. Now you don't have to have somebody convicted in order to avail of this. If you have evidence that this is the case, and that level of serious antisocial behaviour has taken place, well, then you can proceed to serve a 7-day notice terminating the tenancy. But obviously the situation has to be very serious, and the level of proof has to be very high. It is very high in order to avail of that provision. So if you would want to be getting statements or complaints from the neighbours around, or somebody in the household. Maybe there might be CCTV coverage. The guards the incidents might have been reported to the guards, and so on. So this is the sort of level of proof that you'll need in order to be able to stand over the issuing of a 7-day 7-day notice requiring a tenant to quit on those serious antisocial behaviour grounds. I just want to say as well that it is worth mentioning here that a third party can also bring a dispute to the Residential Tenancies Board against a landlord where that third party is directly and adversely affected by neighbouring tenants. And the landlord themselves owes a duty to enforce the responsibilities that the tenant has in relation to the tenancy to each person that could be affected by the actions of the tenant. And where a landlord fails to enforce those tenant's responsibilities, a person who's directly and adversely affected may take a case against the landlord to the Residential Tenancies Board. So it is important that if your tenant is creating, say for example, a noise or a noise nuisance to an adjoining neighbouring house, that you become aware of that, so the neighbour then makes a complaint to you, having gone to the tenant refuses, then the neighbour comes to you as landlord and says, look, we want this noise to stop, it's ongoing. and then you refuse to engage with that or fob the neighbour off, well, the neighbour is perfectly entitled to take a third-party complaint, dispute against you directly to the residential tenancies board. Now, if you are investigating such a complaint, and if it is a nuisance, you want to make sure before you start, going all gung ho against your tenant, that you carry out a proper investigation, and that you make sure that that you have the proof there to confront your tenant with. So you might want to get obviously a statement from that neighbour. Maybe that neighbour, you would want to get that neighbour as well to give you collaborative statements from other neighbours. That neighbour, might get some sort of a sound engineer's report. But it's very important that it's certainly not your obligation to go around knocking on the other neighbours' doors to build the case against your tenant. It's up to that neighbour that's making the complaint to you to satisfy you that there is a problem. I'd obviously engage at a very early stage with the tenant to say, look, there's an issue coming in here in relation to your next door neighbour or whoever it happens to be, and just be open with them from the start. But I've had situations where I've acted for say, for example, I've acted for a tenant, and the neighbour was complaining against the landlord in relation to the tenant that we were acting for. The tenants said no, absolutely, they weren't making any noise or anything like that. They got their own CCTV system in with ability to record sound and vision, and we were able to establish that the dates upon which the neighbour was complaining were days that there was no noise emanating from the tenant's house, and the tenant had proof in relation to that, and also there was no supporting evidence from any of the adjoining neighbours. Now the landlord in that case persisted in going after the tenant, despite the fact that the evidence was on the side of the tenant, that there was no issue there. So we took a complaint against the landlord for the landlord's failure to allow the tenant to have quiet and peaceful enjoyment of the premises. So it's very important as a landlord that you don't sort of, you're not going to take the neighbour's side as such and go after your tenants bald-headedly. That a proper investigation is carried out, and that you respect the tenant's right for peaceful and quiet enjoyment of the property. So in relation to the other main area, I suppose, in relation to the non-payment of rent. So obviously, if the tenant breaches their obligation to pay rent, which has to be paid in full and on time, the landlord can serve a 28-day warning notice, essentially giving the tenant a chance to pay off the arrears within that period. And it should be noted here that the landlord must send a copy of this warning notice to the Residential Tenancy Board at the same time. The period only runs once both have been served. And again, if the rent is not paid within that notice period, then a 28-day termination notice can be served on the tenant, and indeed on the RTB, the Residential Tenancy Board, as well at the same time. So returning to the other grounds for terminating a tenancy, the notice period to quit the property obviously depends on the length of time that the tenant has been in the property, and we'll look at those notice periods in a minute. The other grounds for terminating a Part 4 tenancy are where the property is no longer suited to the tenant's needs. So say a studio apartment is let to a couple who have children, the property would not be able to sustain may not be able to sustain the larger household. Third ground, where the landlord or landlord's family member wants to reside in the property. As previously mentioned, this is not going to be applicable to approved housing bodies, obviously. Where the landlord wishes to sell the property. Now, if this is the case, the landlord must also file a statutory declaration to the effect that the property is going to be sold. It's their intention to sell the property within 9 months. And I've actually acted in quite a few disputes where we've successfully challenged the validity of that statutory declaration. So we need to be careful around the declaration that grounds that termination. Substantial refurbishment of the property, again, actually a few of these cases where we've successfully challenged this ground on behalf of the tenant. And remember now that the law has been tightened up and the landlord will no longer get away with passing off minor alterations as substantial refurbishments. So now when serving a termination notice, you have to give the tenant certain information, including naming the building contractor who's been engaged to carry out the work, and the date upon which the work is to be carried out, how long the work is going to take, and whether or not planning permission was required. And additionally, in the notice itself, or in a side certificate given along with the notice, it should be stated that due to health and safety reasons, the property needs to be vacant while the works are being carried out, and that the period of risk will exceed 3 weeks. Now, once the works are completed on the property, that property must be offered back to the tenant. And the final ground for termination would be far rarer, and that relates to a change of user. So say a change of user from residential to retail, for example. Again, we don't see those. Once one of the grounds has been established, then, as I said before, the landlord needs to ensure that the correct statutory notice period has been given. And as I've said, this will depend on the length of time that the tenant has been in occupation of the property. So more than 6 months, less than a year, 90 days notice, not less than a year, but more than not less than 3 years, but more than 1 year. We're looking at 120 days notice, not less than 3 years, but 7 years, it's 180 days, not less than 7, more than 7, but not less than 8, 196, and over 8 is 224. Now all those periods are they're on the Residential Tenancies Board website, provided for in the statute. So you can look at those and familiarise yourself with them. So perhaps if I could have the next slide, Claire, thank you. So you as the landlord are satisfied. So you're satisfied now that the criteria for terminating the tenancy has been met on one of the various grounds that we've just talked about. So you need to make sure then that you get the procedure spot on. Otherwise, the notice might be ruled invalid by the Residential Tenancy Board, and you will have wasted months. So a tip here is that if you believe that your termination notice isn't invalid, don't wait for the Residential Tenancies Board to make that determination. Just bite the bullet and serve another notice. And I've acted against landlords who stubbornly or perhaps ignorantly, I suppose, in some cases, stuck to obviously flawed termination notices, hoping that they would do or that the slip rule would be applied, only to find that the Residential Tenancy Board then invalidates the notice, and then the landlord is back to square one. I just mean to say that the slip rule as well, by the way, that came in the 2016 Residential Tenancies Act, and it allows an adjudicator or a tribunal to overlook a minor error in a termination notice, and once this error does not prejudice the notice itself, which if it weren't for the error would have been valid. So I should also say that if you as landlord know or ought to have known that a termination notice was invalid, and you can act and you act upon that notice, you'll have committed an offence. And in such a situation, a tenant may get damages of up to €20,000 from you, and the tenant might be ordered back into the property as well. So don't say you haven't been warned. Also as well, and a lot of people don't actually know this, but the 2019 Act brought in the concept of the remedial notice. So where an adjudicator or the tribunal identifies an issue with the notice, and if the adjudicator allows it, you can serve a remedial notice within 28 days of receipt of the determination order. So if that's cropping up during the course of a hearing, make sure you ask the adjudicator or the board to do that for you, to exercise their powers in that regard. So the termination notice itself, well, it must be in writing. An email or a text will not suffice. And I've come across a few people that have received their notices by text. And obviously we've been able to invalidate those fairly quickly. It must be signed by the landlord or authorised agent. So I had a dispute where the supporting affidavit was sworn by a director who said he was the director and that he owned the property and intended to sell it on. But this is incorrect, as he didn't actually personally own the property, rather the company of which he was a director owned the property. And in that case, the argument was accepted and the notice deemed invalid. Another dispute involved the notice being issued by a company which was a different entity to the actual landlord company. So be careful of that one. The reason for termination must be stated clearly on the termination notice. The correct period must be given so that the date upon which the tenancy terminates must be clearly stated. I've had a number of cases where this period has been incorrectly calculated by the landlord. Remember, even if you're a day short, your notice will be deemed invalid. So you have to get it right. Also remember to specify that the tenant has the full 24 hours on the termination day to vacate. Also the period as well starts the day after the service of the notice. But look, as a precaution, I would advise landlords to give a couple of days on top of the statutory notice period. State also that if the tenant has an issue as to the validity of the notice, that they must file a complaint to the RTB within 28 days in receipt of the notice. And again, don't forget to file a copy of the termination notice with the RTB 28 days after the expiration of the termination date. Next slide, please. Conscious we're running out of time a bit. Where a landlord or tenant wishes to assert their rights, then the party can bring a dispute to the Residential Tenancies Board. At first instance, the dispute is heard by an adjudicator, with appeals from that going to the tribunal. Tribunal also provides a mediation service as well. You might want to explore that. So I won't say any more than that. We're a little bit pressed for time. Maybe we go on to the next slide, where we're looking at one of the questions that we received in earlier, related to the perceived singling out of approved housing bodies for inspection by local authorities in their capacity as local authorities and as housing authorities, I should say, and noting that it's unfair that local authorities are not subjected to the same rules. All I can say is that I agree. Approved housing bodies are indeed far more regulated and monitored than local authorities. And remember also that the approved housing body can also be reported by the tenant to the housing authority for failure to comply with the housing regulations, which we will look at very briefly in a minute. And that's in addition to any dispute that the tenant might bring to the Residential Tenancies Board. Now, whether approved housing bodies are being targeted more than, say, other types of landlords, I don't know. But I do know, as previously mentioned, that they are the most regulated in the sector. And we act for many local authority tenants, and it's really frustrating for us, for example, that local authorities do not come under the remit of the Residential Tenancy Boards. So I will refer you, I'm not going to get into, we don't have time, but I will refer you to the housing standard for rented housing regulations, the recent ones of 2019. Again, as I said, the housing authority, the local authority acting as housing authority, get their power, are charged under the Housing Acts from 1966 to 2014 to police and monitor the housing regulations. So I would draw your attention to those. It is, again, as well, it's so you have to have heat. I just mentioned the one exception for approved housing bodies, and so there are provisions relating to kitchen areas, including obligations to provide laundry facilities that approved housing bodies are exempt for, but otherwise they have to comply with all those other regulations. You can see from there. So it's your responsibility as a landlord as well to carry out repairs caused to normal wear and tear. If the tenant contacts you and requests that something be repaired and it needs to be repaired, or perhaps in the case of appliance it can't be fixed, then it should be repaired or fixed or replaced within a reasonable time. If you don't carry out the repair or replace something that's broken down beyond repair, the tenant, well, they can bring a complaint to the residential tenancy board, bring a dispute to the residential tenancy board, but they can also deduct it from the rent, provided that they keep the receipts and then furnish you with the receipts. So that's an exception where they can actually pay less rent because they can deduct any costs of repair in relation to that. Insurance as well. So you're not responsible to insure the tenant's personal belongings, but maybe it would be good to tell the tenants that, because again, tenants come into us, there's been damage caused and whatever, and we're trying to pursue third parties then to get compensation for the tenants. So you should remind tenants that it's their obligation to insure their own personal belongings. Obviously, you have to ensure the structure, make sure that the structure of the building or whatever is insured, but the actual belongings of the tenants are not your responsibility. You're entitled to, and you should indeed, inspect the property periodically. You need to give reasonable notice of this again, and finally reminded that the tenant again is entitled to quiet and peaceful enjoyment of the property. So we're actually, after going slightly over time, if I go to the next slide, and there's my wrap. It's a wrap. And I just want to thank everybody for attending today. We have questions. I tried to answer some of them as I was in the body of the talk there as going along. We'll try and get around to answering the others if we can email them and maybe answers out to people. Claire, that's okay. I'll hand you back over to Claire. Thanks very much, everybody.
Thanks very much. Some people have left, but many of you have stayed on just a little bit over the time. So thanks very much for your participation. And we will follow up with the slides and a link if we can get the talk back up on our site. You can listen over it again if you need to. So thanks everybody for your participation. When I end the session now, you will get a quick survey. We'd really appreciate your feedback so we can learn and improve. So listen, thank you everybody, and we will let you go. Thanks very much to Gary, who's talked non-stop for an hour. I think it was much appreciated. We can see in some of the comments coming in there that people found it informative. Thank you very much, everybody, and we will end the session. Thanks. Bye-bye.
Thanks. Bye-bye.